Yes, this is another installment. United States District Court, District of Maine, United States of America versus Thomas Kavanaugh, defendant. Plea agreement. The United States of America, by and for its attorneys, Richard S. Cohen, United States Attorney for the District of Maine, and J.P. McCloskey, Assistant U.S. Attorney for the District of Maine, and Kavanaugh, acting for himself and through his counsel, Judith Misner, Esquire, enter into the following agreement based on the following promises and understandings. Thomas Kavanaugh will plead guilty to a 2-count indictment, which will charge him with conspiracy to import and importation of hashish into Dutch Neck, Walboro, Maine, on or about May 11, 1981, in violation of Title 21 United States Code Sections 841A1 and 952A and Title 18 United States Code Section 2. The importation to which the defendant will plead guilty is the same importation of hashish described in indictment number 85-00058-B. It is understood that with regard to his guilty plea to the indictment referred to in paragraph 1, the defendant shall not receive a prison sentence greater than 5 years. The defendant may request a lesser sentence, while the government may make any recommendation up to 5 years. If a split sentence is imposed, the term of probation shall be within the discretion of the court. The court shall have the discretion to impose a fine, but the government will make no recommendation that the court do so. The defendant shall be subject to any special parole term required by the statutes to which he is pleading guilty. As part of this agreement, in consideration for the limitations on sentence set forth above, Thomas Kavanaugh agrees to fully cooperate with the United States government. Full cooperation means the defendant will do all of the following. A, he will disclose to the government agents all of his criminal activity and all that he knows or has heard about criminal activity by any and all other persons. He will provide the government or aid the government in acquiring all documents, photographs, bills, records, receipts, and like material in his custody or to which he has access, which will corroborate information given pursuant to paragraph 3 above. He will give complete and honest testimony at any and all proceedings with respect to matters covered by paragraph 3A, whenever requested by the government. He will meet with government attorneys in preparation for giving testimony pursuant to paragraph 3C, and will accompany them when requested for the purposes of locating evidence or preparing for testimony. It is understood that should any of the information provided by the defendant reveal any other criminal activity except those violations mentioned in paragraph 1 to which he is to plead guilty, it will be deemed to have been given under use immunity and derivative use immunity, and it could not be used against him. Defendant shall not receive use immunity regarding his involvement in the offense referred to in paragraph 1. Defendant shall also not receive immunity for any serious violent crime committed or caused by him, should such become known either through his own words or otherwise. Nothing in this agreement will prevent the government from prosecuting defendant for perjury, false statement, or false declaration if committed in conjunction with this agreement. Additionally, defendant understands that the government will not tolerate any further violations of law by him, and should any become known, nothing in this agreement will preclude prosecution of defendant by appropriate authorities for such violations. If defendant should fail to cooperate fully as defined in paragraph 3, the government will be released from its commitment herein, and this agreement shall be null and void. The determination of whether defendant has cooperated fully, as contemplated in paragraph 3, shall be made solely by the United States Attorney for the District of Maine, but must be based upon articulable facts presented to the court. Defendant understands that there are no further or other agreements, either express or implied, other than those contained in this agreement, and none will be made except in writing signed by the parties. Defendant's signature in the space designated signifies his full and voluntary acceptance of this agreement. This agreement is made pursuant to Rule 11A 1C, Federal Rules of Criminal Procedure. Signed, Richard S. Cohen, United States Attorney, by J.P. McCloskey, Assistant U.S. Attorney. I have read this agreement and carefully reviewed every part of it. I understand, and I voluntarily agree to it. Dated 4/4/86, Robert Thomas Kavanaugh. I represent Robert Thomas Kavanaugh as his legal counsel. I have carefully reviewed every part of this agreement with him. To my knowledge, his decision to enter this agreement is an informed and voluntary one. Dated 4/4/86, Judith H. Misner, Esquire.